Thank you for your patience. We will now begin our second panel discussion. The theme of this second part is Diversification of Proceedings in Civil Dispute Resolution and Current Challenges. I would like to introduce two new panelists for this second part to replace Judges Shoji and Katsumata. The first is Chief Judge of the Intellectual Property High Court, Ichiro Otaka. The second is a judge also at the Intellectual Property High Court, Mr. Takehiro Okayama. These are the people who will be speaking at today's panel. I would like to ask the two moderators to again facilitate the discussion from now on. So please, Judge Nakajima and Attorney-at Law Onodera, please begin. So we're going to move into the second part of the panel discussion. I'd like to welcome the two judges to this panel discussion. We're going to have 10 minutes presentation of the situation in each country, starting with the Japanese. I am Ichiro Otaka. I am the Chief Judge of the Intellectual Property High Court. Please look at slide 1. This is about the business court. One of the most recent trends related to the diversification of civil dispute resolution procedures is the introduction of remote proceedings that differ from conventional in-person approaches. Thanks to the digitalization of civil court proceedings, this trend is likely to further expand in the future. The birth of the business court has great significance from the perspective of building the physical environment and infrastructure. The business court is a new building in Nakameguro, Tokyo, with 5 floors above ground and 1 below. From October this year, this building has seen the start of business court proceedings by the Intellectual Property High Court, the Intellectual Property, Commercial and Insolvency sections of the Tokyo District Court. The business court consolidates trials related to IP disputes, commercial and economic disputes, and the related departments in each of the business reconstruction and insolvency processes. So, in addition, the business court is also a front-runner in initiatives to digitalize civil court proceedings, speed up trials, facilitate judicial access, further enhance and reinforce expertise and international awareness, and communication information inside and outside Japan. By doing so, we hope to increase the presence of Japanese judicial system and heighten international competitiveness. Please look at slide 2. The business court was built very close to the famous cherry trees along the Meguro River. You can see it's on the left part of the photograph here. For this reason, the outside walls of the court adopt a brightly coloured cherry blossom motif, which gradually become a lighter shade as you go up the floors. You can see on the right-hand side, you can see the signs in the court on the right-hand side. You can see that these also have a cherry blossom design to reflect the cherry trees along the Meguro River. If you look at the middle photograph, you can see the signs here with the cherry blossom design in the photographs. Let's move on to the third slide. This is the courtroom in room 301. This is ideally suited for the business court in Japan. It has a monotone contrast to create an atmosphere of refinement. The judge's bench forms an arch and is slightly lower than the normal benches to lower the intimidation factor of the court. Let's move on to the next slide. My next topic is the digitalization of civil court proceedings. In Japan, activities to implement and consider the digitalization of various court proceedings are ongoing. In case of the IEP High Court and the Tokyo District Court, procedures to determine the points at issue using IT tools such as web conferences started in February 2020. Then from June, a system for copying and submitting documents called MINTS started operation. In addition, legal revisions to civil cases allowing the online submission of complaints, digitalization of case records, dates for oral argument and the like by web conferences came into force. These were passed and officially announced in May. As a result, we have now reached the age in which proceedings can be carried out online, from arguments in civil cases to the submission of appeals and the rendering of judgments. Using these IT tools, we want to revise and further improve proceedings. For users involved in economic activities inside and outside Japan, we are looking to achieve a new type of court that provides user-friendly judicial services. Next, Judge Okayama will describe the specific operation of web conferences at the Intellectual Property High Court. Hello, I am Tadahiro Okayama, a justice at the IP High Court. I'm going to describe the status of digitalized proceedings at the IP High Court. So please show slide number 5. First, at the IP High Court, virtually all the procedures to determine the points at issue are conducted through web conferences via Microsoft Teams, with both parties attending remotely. Only cases that the representatives of the parties particularly want to carry out at the court, and cases where there is a particular desire to carry out procedures face-to-face, such as cases involving settlement negotiations, are held as an exception on a face-to-face basis. With regard to specific procedures, depending on the case, document settlement agreements and the like describing matters related to the planned proceedings are uploaded in advance and confirmed via chat functions. Other examples include presentations given by both parties via web conferences in appeals. In addition, when an explanatory session is being held that requires contributions from technical advisors, some technical advisors have been asked to participate via the web. The use of web conferences has realized a much smoother process of setting the next court date than before. Although this allows dynamic and easier communication and information sharing between the parties, it has a demerit of making it more difficult to establish common venues and atmospheres, particularly for settlements. Factoring in these merits and demerits, an issue for the future will be how best to efficiently and fully enable the participation of the parties and other relevant people. Then, in June this year, we started the operation of the MINTS system. Currently, the parties, in about 80% of cases that satisfy the conditions for using MINTS, request its use. From the perspective of the parties, MINTS has the benefit of eliminating the need to submit paper to the court. However, several cases involving trade secrets have been reported where the parties have chosen not to use MINTS. In addition, eliminating the need to print out documents onto paper has led to the concern that parties will submit large volumes of written evidence electronically. To combat this issue, we have been trialling a system by which a submission list of documents explaining evidence and reference documents is temporarily uploaded. The parties then select the relevant documents to the points of issue, which are then submitted to the court. Can we see the next slide, please? This slide talks about IP conciliation. Conciliation is carried out by a conciliation committee consisting of members selected by the judge, as well as the public and private sectors. It is a form of proceeding to resolve issues by consultation between the parties. The first of this month marked the 100th year anniversary of this system. The conciliation process has evolved to respond to the needs of society, and IP conciliation proceedings started at the Tokyo and Osaka district courts on October 1st, 2019. The characteristics of IP conciliation can be said to be flexibility, speed, expertise, and confidentiality. The aim of IP conciliation is to realize rapid dispute resolution. Both parties state their intention to use the system and submit evidence by the first conciliation date. Then, then in principle the opinion of the Conciliation Committee is disclosed by the third date. Negotiations before a motion for conciliation between the parties in dispute mean that the points of issue are identified in advance to some degree, and the system assumes that the relevant materials and the like are available. In IP conciliation, the Conciliation Committee consists of one judge from the IP department and attorneys at law and patent attorneys with long experience of IP cases. Judicial research officials may also contribute. The resulting proceedings are expert and stand comparison with court cases. The comparative flexibility and confidentiality of conciliation compared to a court case are the main characteristics of conciliation in general. In IP cases, when the parties are looking for a more flexible resolution, rather than making financial claims or demanding injunctions, or when the parties want to emphasize confidentiality, we think that we can achieve highly cost-effective dispute resolution. In a little under 3 years from the start of the IP conciliation system to the end of August, a total of 32 motions have been carried out, of which 26 have reached a conclusion. The most common type of cases have involved copyright, followed by cases related to patent rights and trademarks. Of the cases that reached a conclusion, approximately 80% achieved conciliation or led to an agreement between the parties, resulting in the motion being withdrawn. This system works to realize smooth dispute resolution in approximately 80% of these cases. The average time interval from commencement to disposition is about 5 months. A web conference-based conciliation process has been adopted on trial basis from December 2021 in some family courts. Web conference has also been allowed on a trial basis for IP conciliation proceedings from July this year. Although jurisdiction is limited, this has various merits such as facilitating participation for remote locations, as well as meetings between attorneys and partners, and particularly large numbers of related parties from companies. When people think about IP cases, people tend mostly to think about large-scale business-related cases. However, issues related to IP are often much closer to home. In the future, I hope that the merits of IP conciliation will become widely recognized and will be used even more actively. Thank you.
Judge Baha, could you please make a presentation?
Thank you very much again. I want to address 3 topics, and I think the first thing I should say is I won't address the topic of business courts in Germany, because there are no business courts in Germany which can be compared with your business court in Tokyo. I think we will have to think about that and have to have a close look on this interesting new concept. So the first item I want to address is also conciliation proceedings. We have this on the next slide. The German Code of Civil Procedure was reformed about 20 years ago in 2002, and there were added some additional rules on conciliation. Now, first of all, it has always been the task of each and every court and each of every judge to try and find conciliation between the parties, making it unnecessary to decide the case. This has not changed. So each court hearing shall be preceded by a conciliation hearing before the court, who then has to decide if the parties do not settle the case themselves. But additionally to that, the court may refer the parties to a special conciliation judge, which was not established before, which was established in 2002. And on top of that, the court may suggest that the parties pursue external mediation. The court is not allowed to do mediation or something which is called mediation, but they can suggest that the parties pursue such remedies in an external process. These are the general rules. There are no special rules for IP cases, but of course IP courts will also try to find a common solution and try to find a settlement if it's possible. they also sometimes refer the cases to a conciliation judge, but the number of cases in which this really happens is very small, at least in patent cases. There are some cases, but I think there have to be special features in the case to come to the conclusion a conciliation judge could be a solution of something which should be tried. So all in all, most patent cases end with a judgment given by the court. But, well, we have these other possibilities. So let's make a large jump to the next topic, which will start on the next slide, video conferencing at the Federal Court of Justice. We didn't have any equipment for video conferencing until March 2020. Then came COVID, and we had to do something because, especially in patent cases, the number of attorneys which take part in oral hearings is very, very high. And we very rapidly developed a system which we call hybrid hearings. This means there will be 2 or 3 attorneys per party in the courtroom, still in the courtroom. All the judges will be in the courtroom, but all the additional representatives, attorneys, patent attorneys, advisors who would be present or would have been present before COVID attend online. Now you may ask, why are there attorneys who attend in person who are in the courtroom? I think the system is quite the same. From our point of view, nobody has to attend in person, so all the attorneys have the possibility to attend online. But for reasons I cannot explain, in almost every case there's at least 1 or 2 attorneys who want to be present in the courtroom. And so we give them the opportunity, as long as, well, the limits which have been brought onto us by COVID are not exceeded. And this hybrid hearing, this concept of hybrid hearing, has turned to be a very, very, well, good solution for us. And it has found wide acceptance among the attorneys. And I think we will offer this opportunity to attend online, if an attorney wishes so, will be a permanent offer, even when and if COVID will be over someday. One side effect of these hybrid hearings was that, well, that we had the equipment to share documents on the screen, visible for all participants, remote and in the courtroom as well. And it turned out this is a very, very good tool in our view. Just as we saw today, there are sometimes certain sentences in the patent description, or there may be some pieces of prior art, and there are some figures which contain some details. And whenever it comes to such documents, they are shared on the screen. Everybody can see what the people are talking about, and we use this feature even if there is no video conference, if all the parties are in and all the attorneys are sitting in the courtroom, just as a means of, well, of visuality of making clear what it's all about. And we also have digitalization with the files and documents, because since January this year, all German attorneys at law, not all patent attorneys, all attorneys at law must transmit all their documents to the court online. There is no possibility to file paper, except the system is down, which has never happened so far. German courts at the moment can keep their records on paper, but this will change in 2026. From then on, all the court records must also be kept as electronic files. And the patent division of the Federal Court of Justice will be the first division at this court, which will switch to electronic filing and record keeping, and we have decided to introduce electronic files by December in this year, so in 2 months. We have had electronic files as an additional means for some years, and we will just get rid of the paper from December, combined with video hearings, combined with screens where you can share the contents of the files. It's a very useful means to enhance the finding of the judgment. I have some small pictures from 2 of our courtrooms, which are on the next slide. You may find some similarities in the shape of the bench with the new business court if you ever visit it. You see the microphones on the table, and you see 2 screens for the attorneys and 2 screens for the judges. And you see also 2 cameras, one on the bench and one on the table between the attorneys. So we have 2 different views from the courtroom for the people who attend online. Well, and there's one additional topic which, does concern Germany, but does not also concern Germany, but 15 more European Union member states. We turn to the next slide. This is the Unified Patent Courts. For many years, on such occasions, we had to say the Unified Patent Court will come soon, but I cannot tell you when. Now we have an official start date. It was officially announced by the court itself. It will start on the 1st of April next year, 2023. The judges have been selected. The president of the first and second instance courts will take office next week. So the system is going, and now I think I can say the UPC will start. It has a court of first instance with several divisions, one in Paris, one in Munich, several in all the participating states, 4 in Germany. It has a court of appeal, which is located in Luxembourg. And let me end this presentation by proudly announcing the president of the Court of Appeal will be a former judge of the Federal Court of Justice, who is in my division for a few days and who will be appointed as president next week, as I already said. Thank you very much.
Thank you, Judge Baha. Now let's move on to another country in Europe, the United Kingdom. Justice Burst, could you please begin your presentation?
Well, thank you very much. I'm going to start by discussing video hearings and then some other matters of use of technology in our courts. So we have had video witnesses in the English courts since the 1990s. It was not a big part of the procedure, but it was something that we did. But like everybody else, when COVID came along, we started using video very extensively. And in fact, we were very proud of the fact that in our business court, within the same week that we locked down because of COVID in March of 2020, we turned all our cases into remote video cases with no attendance by anybody. And that meant that we didn't have to adjourn very many cases at all. There was a very small number of adjournments, but it was very small. And we kept the business courts running really brilliantly, and my colleagues should be congratulated for that. In fact, the business court in London, which the intellectual property court is part of, rather like what you've just opened in Tokyo, really led the use of technology to beat the pandemic in our court system, and we gradually moved out remote hearings into the rest of our regional courts. within a very short space of time. Today in the UK, we don't have any formal COVID restrictions. That doesn't mean we've beaten COVID any more than anybody else, but we don't have formal restrictions. And so much of our work is now back in a physical courtroom, but rather like Judge Bacher was explaining in Germany, one of the things which has now become very popular is a kind of hybrid hearing in which, particularly in the patents court, when you have a foreign party, which is very common in the patents court, the foreign party's employees there who are interested in the case, what they wish to do is rather than fly halfway across the world to London, London's a nice place, but it's a long way from America or Japan or wherever, they would like to watch the hearing remotely, and we offer that facility now. And that's completely new. We never did anything like that before, but now we do, and it's very significant. We don't use remote hearings now so much for big cases because, rather like in Germany, the lawyers seem to want to come and see us in person, which is very nice, I suppose, although I think remote hearings work very well. And in fact, in our lower courts, in civil justice generally, remote hearings are still used to a very, very great extent. They're not perfect. There are many problems of one sort or another, but one I want to mention on the slide there is it's described as difficult to overbook. If I could just explain what I mean by that. In our local county courts, we're dealing with general civil justice. One of the ways in which our courts operate is that they will do something called block listing, which means they will tell, say, 10 parties, 10 cases, that you will all come to court tomorrow. Well, not tomorrow. Let's say you'll all come to court in 6 months' time and give them a date. And they will all be listed for the same time. And there will be enough judges available that in the very unlikely event that all 10 of those cases fight, we will be able to cope with them. But most of the time, all 10 don't fight. Usually only about 5 come to court because the other 5 have dropped out. And the courts can manage the order in which they deal with those 5 cases during the day, because all the parties are physically present in the court. Some of the parties may have to wait some time in the courtroom while they're waiting for the hearing to happen. But that's a way in which we manage our small civil justice system very efficiently. It's a very efficient use of court time. The problem with it is you can't do it with remote hearings, because it relies on the parties physically being in the court building waiting for a hearing. And when you try and do it remotely, we've just never found a way of making it work. And it is a significant problem because it means that although in some ways remote hearings are very efficient, in this particular respect, we have great difficulty making our system as efficient as it used to be in that way. And what I've mentioned as guard time, one of the problems is that you can't squash hearings together as efficiently if you have a video hearing, because it takes time to set up the hearing, whereas if they're physically in court, the usher can usher the parties out of court and usher the next people in very, very quickly, and the judge can do it. So that's part of the difficulty. If I move on to the next slide, please. So we are like everyone else in the world, doing a lot of projects to digitize our court system. In our business court, we've had electronic filing and electronic file keeping since 2015. That's very well settled now, and our lawyers are very used to it, and our court staff are used to it, and it's very good. But we also now have a major project to digitize the process of the justice system itself. And that's not just electronic filing. That is a computer system in which the computer tells the parties what they have to do as the case proceeds. And it's very useful for small litigants. Patent lawyers don't need it, I should say, but a lot of smaller litigants, people without legal representation, because the case is very small, need that kind of help. And we have our system which will do that. It's still very early days, but it will tell them when the next step is they have to do it, and it will have if they go on the website, there's a countdown, a timer that counts down the days to tell them when the next step has to happen. But for that to work, the system needs a sort of intelligence. It's not machine learning, not that kind of AI, but it is a system in which the computer actually knows what the timetable of the case is and acts accordingly. So that's a very important project. One of the problems with it is it turns judges into IT project managers, and that's not really why any of us became judges, but that's one of the difficulties we have. It also changes the management information that we have for the operation of our courts, because once the computer has all this information, it becomes a very rich source of data, and that can be quite something to manage. Also, we, of course, are using more electronic documents. That's become very standard. But interestingly, what does happen is that the lawyers tend to come to court with paper. So even though the judges, like me, sit there with a laptop and an electronic file, you find when the court door opens, the parties are all there carrying big boxes of paper. And that's telling you something about how people want to work. It's not up to us what they do, that's what they want to do, but it is quite a notable feature of our litigation. If I flip on to the next slide, please. So, two other things that are going on in the UK in this area. We're trying out a system of our small civil claims being decided without a hearing at all, on the basis the judge can read the papers and come to a decision. We've always had that possibility if the parties agree to that mode of determination, but we're trying a system in which the judge says this is a case which is suitable to do that. Even if the parties say they want a hearing, they may not get one. And that's created some controversy in our system, but we're trying it out, and we hope that we will be able to find a way, again, of efficiency. This is all about efficiency, trying to get cases done as quickly and fairly as possible. So I'll be very happy to come and tell you one day about the answers to that project. The other problem we have is a huge increase in the volume of material in cases. Now I'm talking about big cases, so patent disputes, big business disputes. The amount of evidence, the amount of stuff which needs to be grappled with in these cases is increasing enormously. And part of that is because of the digitization of our lives, emails, WhatsApp, Messenger, all these are digital records which may be relevant to a case. And how do you grapple with that enormous amount of material? And this is something where we're seeing the beginnings of the use of artificial intelligence. Machine learning technology is now used, and our judges have sanctioned its use by the parties to sift through that material in order to find the relevant material. And that'll be a very interesting development as it goes on. Some people have questioned whether it's okay to have the machine deciding on the relevance of material. But in the real world, with that volume of stuff, the only alternative would have been to employ a 22-year-old paralegal graduate who probably wasn't any more interested in the material than the computer to sift through it. So we think that a well-made computer system might be better than a bored 22-year-old, but we will see. And that's all I wanted to say about our technical stuff. Just a word on the Unified Patent Court, very briefly. The UK is not in the Unified Patent Court. At a personal level, I'm very sad about that. I put a lot of my life in the mid-2010s to help make the Unified Patent Court as good as it can be. I think it's a brilliant court. I'm not supposed to say that because I'm a Brit, but it is a brilliant court, and I look forward to interacting with it from our soggy island just off the coast of Europe. Thank you.
Thank you, Justice Burst. Finally, from another case law country, the United States. Judge Jordan, could you please start your presentation?
Yes, thank you very much. First, let me note that the business court building that was described by Chief Judge Otaka is absolutely magnificent. We had a chance to look at it yesterday, and it's truly beautiful. Congratulations to the court system here in Japan for a wonderful innovation and a wonderful new home for the business courts. I wanted to talk just briefly about some changes in the United States, mostly driven by COVID, but which look like they will have long-term consequences. As you may know, probably do know, In the United States, proceedings begin before people show up physically in court with detailed pretrial discovery. And the discovery changes have been significant in light of COVID, particularly with respect to depositions. The taking of testimony before going to court is a feature in virtually all civil cases in the United States, and especially in patent cases, which have high stakes and consequently have parties willing to spend significant sums of money to develop their evidence. Because COVID made travel difficult or impossible and made it challenging to bring people together for depositions, people learned very quickly how to handle these things with remote technology. There was and still is occasionally some battling by the parties over whether a particular witness's testimony needs to be taken in person because it's such a significant aspect of the case, and those fights get addressed by either the presiding judge on the case or an assisting judge called a magistrate judge. But by and large, deposition testimony is taken very, very frequently by remote means because the cost savings are enormous and the parties are grateful for that. The other kind of remote events that are taking place during the discovery process are discovery dispute resolution hearings. It may not surprise you to know that if you have lawyers together, an argument is likely to erupt. And so there's frequently discussion at these depositions or in anticipation of them or with respect to written document exchanges where the lawyers are not seeing eye to eye and they need the assistance of the court to resolve their problems so the process can move forward. When that happens, in days of yore, that was often taken care of by phone, but sometimes required people to come to court. It's my impression that those kinds of disputes are handled now by remote means, either telephonically or by a Zoom meeting, and that again represents a cost savings for people, which is good and helpful. I should take a moment here before we turn to the next slide to note that what Lord Justice Burst just mentioned is the case in the UK is certainly the case in the United States too, with regard to electronic discovery. That is, the volume of information that is produced in civil cases, and most especially in patent cases, which are document intensive, is extraordinary, and therefore often requires the use of special electronic discovery counsel to get into the mix, who are prepared to argue and fight over search terms, search methodology, statistical sampling of documents using the search terms, because otherwise it just becomes unwieldy and impossible to manage. The digitization of our lives has indeed altered the way discovery is handled. I used to be one of those 22-year-olds in a room with boxes and boxes of documents, but nobody does that anymore. And I think that's an advance. That's a good thing. Let's go ahead and move to the next slide, please. Once you get to court, the COVID protocols, again, have had some significant influence. Because the United States still has the Seventh Amendment requirement to permit jury trials in civil cases, it's not easy. In fact, it's nearly impossible to conduct a remote jury trial. It's just too difficult to put everybody together and have that work. It did happen a little bit, but it's very complicated to pull off. As a consequence of that, jury trials were put on hold for a long time, and we're just now working our way through that backlog. Bench trials, that is, trials to the judge as the fact finder, did occur and did get handled remotely. I presided over a patent trial which had witnesses from all over the world, and the best part about it was I had the most magnificent courtroom I've ever had, which was a completely fake background on my screen, but it made me feel very, very official. The other really good thing about it was that the lawyers were extraordinarily cooperative because everybody knew they needed to be in order to pull off a remote trial. It did result in some challenges, as you can imagine, when you are trying to present documents to witnesses and they're halfway across the world, and you're attempting to cross-examine. And those things that are typically done easily in a courtroom are more, it is more challenging and more time-consuming to do them remotely. And perhaps for that reason, and because it just seems to work better to be able to evaluate the credibility of witnesses and to be able to handle the multiple nonverbal cues which people send to each other in the course of a proceeding. It is the case that trials now are back in the courtroom. People want to be in the courtroom. It's true, as Judge Bacher said, and as or Justice Bursch said, that the lawyers want to be there. I think they believe they can be more persuasive if they're in front of the judge personally. I like to have them there personally, and so trials are now very largely back in action because I think people view them as less effective when they're handled remotely. Can we have the next slide, please? The other kind of remote proceedings that still bear some imprint from our COVID protocols are the settlement conferences. Settlement conferences in the United States federal system, as you know, in the United States we have a federal system with federal courts, of which I'm a part, and the individual state courts. Not speaking to the state courts, which vary significantly from state to state and even within some states from court to court. In the federal system, there is no rule that requires special settlement conferences or conciliation efforts, but it is quite standard practice in most federal courts, I believe, to encourage settlement and to, in fact, refer parties to mediation. And in the District of Delaware, where I served as a trial judge before becoming an appeals court judge, the standing order was in place that required parties to submit to mediation efforts at the start of the case. We did not have a difficulty finding judges to assist with that because the magistrate judges in the court perform that service and do a beautiful job of it. And many cases are settled through their skill and their experience, and that includes in challenging matters like patent cases. The District of Delaware has an extraordinary volume of patent cases, including and especially pharmaceutical cases, where I think they've got something like half of the pharma cases in the country. And these magistrate judges are superb at handling these, and for a period of time, because of COVID, they were handling them using remote means. I think that will still happen to a certain extent, but for the same reason that people want to be in front of judges when they're arguing to persuade in a formal hearing, they frequently want to be in front of the judge that's handling the mediation personally to attempt to enhance their advocacy efforts. So settlement conferences are now being done in person again, and it's I think people would say it's effective, and they're grateful to be back in the courtroom or in the settlement conference room with the judge. Thanks.
Thank you, Judge Jordan. Many topics were introduced by the panelists. In this discussion session, I would like to pick up just a couple of topics. First, as to remote proceedings, Judge Jordan pointed out that sometimes the remote trial is less effective. I would like to confirm about this matter in Japanese.
Have you felt that remote proceedings are inefficient? So in Japan, proceedings related to points of issue in disputes using telephone-based conferencing has been established for a long period of time using Microsoft Teams. So we look at the screen as we carry out these proceedings. So compared to before, as we heard before, we use the chat function and screen sharing to carry out these consultations. So we can also see people's faces and their expressions. So rather than telephone conferences, web conferences are more effective. We feel that these are quite useful. On the other hand, when existing proceedings are carried out remotely, for example, in settlements, so we have to consider various issues from our technical advisors, whether their expressions are sufficient that we can judge from them. So we have to make various improvements and consider other people's worries.
Kind commented from the perspective of the court. Yeah, so from the perspective of the attorney, Mr. Shiroyama, have you ever faced any difficulty in communication with a judge during a video conference?
Okay. I personally have not yet experienced with the settlement conference on the web so far, and I personally have not felt any difficulties arising from that kind of less nonverbal communications on the web. And I think some judges are trying to use the new tools for better practice. And I understand some, for example, some judges are trying to use the document sharing function of the teams and write down what was discussed and what was agreed at the end of the web hearing. And honestly, it takes some time because as a counsels, we have to be very careful and we becomes very protective if what we already told is written in the record. And I agree. It's good practice for efficient and productive process. But I think it's tough time for counselors.
Thank you, Mr. Shiroyama. I had one hearing with technical expert remotely. It's really hard to the grasp intention of a question of technical expert. But so that I totally agree with efficiency and cost-effective procedure remotely. So that I asked judges to utilize this very convenient system in proper and efficient manner. Thank you very much.
Thank you. Well, the point now made is could be some difficulties which may arise from increased necessity of verbalization in remote proceedings. Regarding choice between real attendance and the remote participation, I'm interested in hybrid proceedings which seemingly could have advantages of both in-person and remote proceedings. Judge Baha, could you let us know more about the advantages of hybrid hearings, if any?
Well, as I already said, the main advantage for the court is that the courtroom is not as full as it was before. On the other hand, as I already said, there is a strong wish from the side of the attorneys to attend physically, at least 1 or 2 attorneys per party, and so far we have done nothing against this wish. So if the parties wish to have the 2 of the attorneys in the courtroom, we will try and make it possible. So I think it's a good compromise from our point of view, respecting the wish of the attorneys without having a crowded courtroom.
Yeah, thank you. The wish of attorneys was mentioned by, I think, every panelist. Justice Verso, Judge Jordan, do you have any comments on the wish of attorneys to come to court?
I do. I think let's ask ourselves why we're here. Why didn't we just do this online, right? There's something valuable about being together in person that you can't get when you're online. And that's why all of you made the trip here. That's why you were kind enough to bring us here. And one of the most significant things that happens, and I think lawyers are awfully smart people and they recognize this, is that there are conversations that happen on the side, not in the courtroom necessarily in the formal setting, but in the hallway before you go in or at the edge of the courtroom that have real effects, including settling the case, that just don't happen when you're all online because it's impossible to have those side conversations. So I don't have a hard time understanding why lawyers want to be in the courtroom. There's a multitude, I think, of good reasons to want to be together in person, including the possibility of having a quiet word to the side which can make a difference in the resolution of a case.
Yeah, thank you. Justice Burst.
Well, I agree with that. Can I just add one personal experience? Recently, we have had a different kind of hybrid hearing in London. We've had trials, and in fact, one was my trial, in which it was meant to be an in-person case. We were expecting it to be. And then the judge got COVID. Not the parties, the judge. And it was a single judge. So we had a hybrid hearing with, it wasn't bad COVID, thankfully, but with the judge on the screen in the courtroom and everybody else in the courtroom. And we've done that now quite often. And it's remarkably effective, actually. It really is, well, it's better than adjourning the case. And you can, as a judge, you can control what happens in court just as well, I think. But the parties can interact in a personal way. I'm not suggesting we do every case that way, but as a backstop when you have a problem, actually, it's very effective.
Thank you very much. Well, I'd like to touch on other topic of the volume of evidence arising from digitization. Well, actually, yeah, I would like to ask to Japan on this matter.岡山裁判官、日本で
So, Mr. Okayama, Judge Okayama, you've talked about mints, but compared with the system of paper, how do you think the system has changed between mints and the paper-based system in the past? After we started the introduction of electronic documents, it's not been very long. But compared to before, when we used submissions by paper, the submission of electronic documents I think the submission process has become easier compared with before. We had some very, very large cases about related to IP, and there is still some concerns about increased submission with the new electronic system.
So probably it seems that how to select evidence and to share a common understanding about which are crucial pieces of evidence between the court and the parties will get much more important after introduction of such system. Well, I would like to go to the topic about the UPC. Judge Bahar, I would like to know, what do you think of probable impact of establishment of the UPC for the German courts, especially from the perspectives of international harmonization and possible forum shopping through opt-out?
Well, that is a very good question. So at the moment, without the UPC, there are some forms of forum shopping because there are many national courts in Germany, in Europe, and sometimes the parties are able to decide, should we have litigation in the UK, should we have litigation in Germany or in France or anywhere else. Once the UPC starts to operate, these opportunities will rise, because you, as in the first 7 years, you will still have the possibility to go to the national courts, but on top of that, you will have the possibility, instead of that, going to the UPC. So I think it's a major task for the UPC as well as for the national judges to find as much harmony as possible in order to avoid forum shopping. Of course, there will always be forum shopping because parties may think, even if the courts apply the same rules, then this judge may be more favorable to my case than another. But it would be very harmful if the legal concepts, if the basic rules which are applied would differ between all those courts involved. And therefore, it's, I think, a common task for the UPC as well as for all the national judges to keep and find as much harmonization as possible. We will have to wait and see how this works, but I think all of the judges who are involved see this problem, and I think all will do their best to avoid that this really gets a problem.
Thank you very much. Finally, I'd like to take this valuable opportunity to ask overseas panelists about court in the future. Considering recent situation concerning digitalization, what the court will be like, in what direction the court shall proceed, or what would be challenging problems to be overcome as to the court proceedings for patent cases or civil cases in general. First, Justice Burst, could you share your view to us?
Yes, thank you. Well, blimey. I tell you what I think, not about patents, not really about intellectual property, but about civil justice in general. I think one of the questions that we need to ask ourselves relates to eBay, the eBay system. Why am I talking about eBay? eBay has an online dispute resolution system. eBay runs one of the biggest civil justice systems in the world. No, that's what it does. And it runs it without serious complaints. I mean, there are complaints, but they're handled. It doesn't have all kinds of the aspects which national courts have, which we have in the UK, you have in Japan, and it's very efficient. And my view, my personal opinion, is that civil justice around the world, in the industrialized world, needs to learn something from this. And I don't know exactly what the answer is, But I think we need to be mindful that there are other ways of doing civil dispute resolution which are effective and which the citizens of all our countries use. And we're not as judges and in a justice system as lawyers and judges, we're not in the business of trying to sell something. That's not our function. Absolutely not. On the other hand, we are trying to have a system which provides access to justice in a fair and appropriate and reasonable way. And when it is obvious that there are other ways of doing it which appear to achieve that, I think there is something to learn there. And I suspect, if you want to look in the long term, there is a question we need to ask ourselves about legitimacy. Because I'll tell you what I think judges should be human beings in a courtroom. That's what I think. Seriously, I do think that. But maybe I'm mistaken, because these eBay systems appear to have legitimacy, and they do not have human beings sitting in courtrooms deciding the cases. So maybe there are other ways in which we need to resolve civil justice disputes. That's what I think.
Thank you very much. Next, Judge Jordan, what do you predict, or what is your view?
Well, it's sort of adjacent to or akin to what Lord Justice Burst just mentioned, and that is that as we move forward, there's going to be a great need to figure out how to reduce the cost of the delivery of legal services and dispute resolution. One of the advantages of the United States system is there are so many courts, so many different state courts, as well as the federal system, that there is an opportunity for innovation. We call it sometimes the laboratory of democracy, and the idea is that you might see develop in one state court's system a method for dispute resolution which appears to be successful in reducing cost and increasing accessibility. And that's a very positive thing, and it gets picked up. I sit on the advisory committee on civil rules of procedure, and I can tell you that we take very seriously our responsibility to look around the country and see what's happening, to try to understand who's managing this system the best, who's figuring out how to provide for the delivery of civil justice in a way that's most effective and most particularly cost effective. If you look especially at domestic relations courts, there's an extraordinary demand on the system, and it's difficult to meet those demands, and we're struggling to keep up. So the big challenge is going to be, how do we do this better and cheaper? I get a little worried about the robo-justice. I know what is happening in the commercial field, as Justice Burst mentioned. It's also, I understand, happening somewhat on an experimental basis in China. But I'd always like to know that if I had a dispute, it wasn't going to be resolved by an algorithm that I didn't know about the intricacies of. It was going to be resolved by a human being, even though I didn't know the intricacies of that person's mind either.
Thank you very much. Judge Bahar, could you share your view?
Yes, I agree with everything which was said by my colleagues. And I want to add just one other aspect, because I think there will always be cases, and there will always remain cases which need to be decided by a judge, and which need to be decided, I think, in the same way in which they have been decided for the last 100 years. So there may be certain types of cases which can be handled by a machine, and we may identify more and more cases which are suitable for that kind of dispute resolution. But I cannot imagine that, especially in the field of IP, we will find too many of such cases. On the other, just the opposite, I think real IP cases which we handle today and which we have today decided by courts will be decided by courts and by human beings sitting on a bench or perhaps at home before their Teams or Zoom screen in 100 years as well as today. Courts will have more digitization. Courts will make even more use of all the technology which is evolving at the moment. But if it's a real patent case, if it's a real trademark case, you will have to have good lawyers to argue and to bring your arguments, and you will have to have good judges deciding these cases. And so I'm reached the age in which I can well calculate when I will be retired, so it's not a problem for me. But I'm very confident that future generations of judges, and especially of IP judges, will have enough cases in where they are needed and they will have to decide. And so I think we can relax and wait and see what all these new technologies and these new forms of dispute resolution will bring us. Thank you very much.
Yeah. Thank you very much. Well, I'm afraid our time is up. I'd like the panel discussion to a close. Thank you all for your participation and attention.
Thank you very much. This concludes the second part of the panel discussion, Diversification of Proceedings in Civil Dispute Resolution and Current Challenges.